Hello, I'm Advocate John Simpson. I'm a member of the National Consumer Tribunal. The Tribunal is an adjudicative body similar to the High Court that adjudicates on consumer law matters in terms of the National Credit Act and the Consumer Protection Act. Today I wanted to tell you about improvements and progress we have made in adjudicating on debt rearrangement applications. So the Tribunal started in 2007, and then we started receiving debt rearrangement applications. And these soon grew to be tens of thousands of cases that we had to adjudicate on. Just to give you a bit of background, debt rearrangement applications arise when a person is in financial trouble and they then approach a debt counsellor for assistance. And the debt counsellor can then go about rearranging their debt. So essentially that means they make proposals to the credit providers for the consumer, proposing lesser payments or reduced payment over a longer period. If all the credit providers accept this rearrangement plan or debt rearrangement plan, then the debt counsellor can submit the application to the tribunal, and the tribunal can then make this debt rearrangement agreement between the parties an order of the tribunal. It's then binding on everyone. So essentially, as I say, when we started in 2007, we received a few of these applications and we used to do them in court. So all the parties would appear, we would hear the matter, consider the application and then grant the order. Now this worked fine while there were 3 or 4 applications per year. However, they soon increased in the number. We started receiving hundreds of applications from 2009 to 2010. What we would then do is we started hearing the applications in chambers. That meant that the parties didn't have to appear in the tribunal. Their cases would be given to the tribunal members to work on in their offices. So in their offices, they'd have to go through the application, draft the order that we were going to make, and then it's issued by the registrar. Now this took some time and there was a lot of typing involved. So the most we could do in those days was we were given 8 applications to do over a period of 3 days. Now when we started receiving hundreds and then thousands of applications every year, it became untenable and we just couldn't maintain doing 8 over 3 days. So we had to find a new system of adjudicating on these cases. So then what we came up with was motion courts. Now we introduced the motion courts in 2015. What that essentially meant is that the tribunal members and staff would go to different locations throughout the province at certain dates for a week at a time, and the debt counsellors would then bring all their applications on the motion court days, and we'd adjudicate on them there and then and grant the orders. So using that method and in motion courts, we were able to finalise about 30 cases per day at a motion court. This was far more than the 8 per member over 3 days. However, as I said, again the numbers kept on increasing, and now we started receiving tens of thousands of applications every year. So again we had to come up with a new method. So what we started developing is the case management system. So our in-house IT department did a magnificent job by developing a case management system. What this system allowed us to do is that the filing parties, like the debt counsellors, file their applications online and load it into our case management system. The tribunal members could then adjudicate online on the case management system, grant the order, and it's immediately emailed to all the parties. This system worked very well, and we were able to increase the number of cases we adjudicate on till from 24 to 32 and eventually 40 cases per member per day. So this made a huge difference to our productivity and efficiency, and we were able to start working on the cases far quicker and finalise them far quicker. Then we came up with a new process again for the format for the debit order, for the debt rearrangement order. Essentially, the previous version that we had, you had to compare information between the draft order and all the letters that the credit providers give to the debt counsellor wherein they accept the proposal that was made. Now there's a lot of checks that one had to do. The tribunal member had to compare a lot of documents with each other to make sure that the order was correct. And the debt counsellor had a lot of information that to complete on the case management system. So the process we came up with was to actually make the consent order or the debt rearrangement order far simpler. So we had a standard order, and then all the debt rearrangement letters that the credit providers send accepting the proposal simply get attached to the actual order. Now this made it far simpler for the tribunal member to make sure that the information is correct. So now they didn't have to compare information at all. The information in terms of the acceptance by the credit provider was right there on the order. So it made it a lot simpler. And also for the debt counsellors, we didn't require them to add all the different information from the various loans and the credit provider on the system. It was far simpler. They had far less information that to add. So this change that we introduced to CMS in 2020, just last year, again made a huge difference. Now we're able to adjudicate on 80 cases per member per day. So this improvement has actually led to our outstanding case roll for DRA matters, reducing from about 20,000 cases that were always waiting to be adjudicated on to less than 4,000 now. So essentially, if we're receiving about 3,000 new cases every month, so over 80% of all our cases on our system are current cases, less than 15 days old. So we're very proud of that achievement, and we're going to continue making efforts and strides in ensuring that we deliver the best service we can for our stakeholders and for our filers, and most important of all, for the public. Thank you.